Hello. What's going on? 1, 2, and 2? Um, Muted, right? Because of course. Uh, uh, really? Is it still Nicole? Hmm. Never mind. Okay. Okay. Um, Hi. Thank you to everybody last moment. This is all down to Hella. And I put some where to begin? If you're here, you already know about what has been going on, and I want to pick up where Jay had left off and where Hella really got everything sort of kickstarted with finding this case. And I think the links are available to Hella and her work, Jay and her work. I think Dolly's probably in there somewhere. So I know people are going to please take a look at that. I've also there's Slutherson. Okay, good. And so what I want to do is kind of give you people that are new to me. I am a journalist of sorts. I was for many years. Many of you know I'm a student going back to school, 180 years old. Anyway, um, so I have been looking at bad actors in this case, mostly in reference to Delphi. So we're talking like, um, the Lauren and John of it all, and Delphi folks will know, looking at Murder Sheet and their bullshit, which I think will probably come back around to this, but when bad journalism meets up with bad professional licensed individuals, and in this case it's all been about Lauren and John. Everybody knows it's been all about that ridiculous 9 Hour Live, and pulling on the skin suits of victims, and trying to ingratiate themselves um, to further their enterprise, and it's an enterprise at this point. So if you haven't seen Hella's video, I want to talk a little bit about that, just to give some background because man, oh man. And then we're going to go through the docket, which is, I'm not going to kid you, it's really rough. It's really rough, y'all. And so um, the the things that have been read so far from the docket are nothing compared to what else is publicly available. Now, I'm not gonna be reading all of it because it's graphic. It's more graphic than what, "Hey, Fiend, thank God you're here." It's more graphic than what Jay read, um, and it's deeply disturbing on many levels. As a case, it's incredibly disturbing. It was this case that actually the FBI in Nevada had, um, gotten on to. Um, but it's also incredibly, disturbing from the fact that, uh, Dr. John Matthias was allowed to even touch this case with a 10-foot pole and make what has been demonstrated in court documents to be an erroneous finding, to let this person back out onto the streets with minimal supervision. That could be subject to, you know, uh, any sort of, modifications or, if they wanna come out and make some corrections, that's great, but we have a court record. So everybody go check out Hella, but the long story short, let me pull her up. Sorry. I just know that some people don't know who I am, and that's alright. You don't really need to. Um, let me pull actually, let's do this. I want to look at this first as a sort of grounding in this case. Um, yeah, I agree. Um, it could be, me. Hang on. Okay. Is that better? Is that better? Mm, I don't know. Could be me, could be, platform. But, yeah, so it's really awful. So this is what I was able to find sort of on last minute, because all this sort of happened this morning. But this is the person, and this is from the, US Attorney's Office in the District of Nevada. Um, and it goes through the, arrest and sentencing. Um, and this is a sentencing that was handed down after the disgraceful, erroneous, uh, you know, uh, evaluation that John Matthias did. The man, ended up and we're gonna go through some more documents, and we're gonna go through an actual transcript of the proceeding, which I think really puts a fine point on what everybody else has found and why it's so critical to understanding why this man is not a professional, to be listened to, and I think that that brings me some comfort based on the evaluations of Mr. Richard Allen that were completely false and erroneous. Anyway, so Las Vegas, so this was from, Tuesday, November 16th, 2021, and it's a press release, and I've linked to this, but it's a Las Vegas man is sentenced to 27 years, right? So 27 years. I want you to take that in context, and juxtapose that with what Hella, um, read out, was the downward sentencing that, Dr. John supposedly, put forward as a justification to give this guy less time. Um, so, yeah, still, this person was given 27 years for receiving, for attempting to sexually and again, this is gonna be rough, sexually exploit a child and receiving child pornography using a file sharing network. Um, so basically, according to court documents and now this case goes back so there's paper on this guy, and we'll go through the docket. Um, according to the court documents, on June 2016, Richard Fred Dittmer, 25, utilized a BitTorrent file sharing network to download child pornography during the execution of a search warrant in Dittmer's residence. I wanna put a note in here that I think that, um, that this is indicative to me of where all of the horseshit, frankly, knowledge that, Dr. John has about working with the FBI and some bullshit that I don't know if it was Jay or Hella had spoken about, where he was talking about how long would it take to download this much child pornography, and he had reached out to somebody at the FBI. I think we can kinda see where his his yarn is being spun from, and I think it might just be this. It might just be this, literally, and I'm gonna start getting really angry, so I'm gonna try to keep that in check as we go forward, but anyway, so from 2016, this guy, right, as well as uploading, CSAM to YouTube, a forensic examination of electronic devices belonging to Dittmer 365 images and 18 videos of pornography, sadistic, masochistic. Like I said, this is awful. Um, well, on pre-trial supervision, I want you to keep this in mind because now, the next time that, Lauren Matthias wants to pull on the skin of a victim and cloak herself in it as caring about the victims, I want people to remember this. These are children. And this is some of the most disgusting shit I've seen. And, I'm just being really honest here, but to see what John Matthias did, not only his lack of education on this guy or willful ignorance of what this person did, the next time they want to wrap themselves in victims, do not let them because it matters. This is where I get really upset at people trying to call themselves journalists, 'cause I may not be in that game anymore, but what I can fucking tell you is, you no, uh-uh, no, mm-mm. This case was brought as part of a Project Safe Childhood, a national, initiative launched in May 2006 by the Department of Justice to combat the epidemic of child sexual exploitation and abuse, led by the U.S. State's Attorney's Offices and Criminal Division of Child Exploitation Obscenity, okay? This was investigated by the Internet Crimes Against Children Task Force and the Las Vegas Metropolitan Police Department and the FBI. Assisted U.S. Attorney Bianca Fucci and Christopher Burton prosecuted the case. Hats off to these 2 prosecutors. I'm not often a fan of prosecutors, but man, oh man, they did a hell of a job. Um, okay, let me try something else here. I'm sorry, it could be my headphones. Ah, um, but yes, I will. Uh Ah! Okay, let me try this. Please stand by one moment. Talk amongst yourselves. Let me try to get an actual chord. Sorry, this is it's all here last minute. Is this better? Hello? Is this better? Is that better? M'kay. Alright, moving on. Um, so I don't know what I was ranting about, but, anyway, so, I like to give a shout out to, Las Vegas, man, the FBI. So again, FBI, right? So what we know from the, earlier, uh, reading and going over the documents by both Jay and Hella is that, and I'm gonna pull those up now. Let me take this down, and please let me know if there's any more issues with sound. Um, I just, okay, great. Um, I'm a mess. I'm just an old bat out here in the world. All right. Um, okay. So this is what the boop boop boop. So this is what. Okay, great. Huzzah! Huzzah! Okay, thank you. Okay, great. There's a question higher in the chat. Okay. Yeah, put a question mark in it if you have a question. Um, I don't know. I can't find it. If somebody can repost it, that's great. Just put a question mark in there, like a giant question mark in front of it. Representing other old bats. Yeah, that's me. Okay. So, question: was John linked somehow to a defense lawyer, friendship, or so, or with the defendant himself? That's a good question. I mean, I think I actually reached out to Hidden True Crime, to Lauren this morning, to see if they wanted to make a comment on this. Um, and I mean, I haven't heard back. I do think that it's fair to give them a chance, although I don't know why at this point. But, it's just that sort of due diligence. I have no idea. I am going to spitball, and Vegas is a small town. I mean, really, right? Small world, small town. Who knows? Maybe they went through UNLV. Who knows? But I'm sure that if anybody can get to the bottom of it, you can. Slutherson probably could. I know, but you know what? Uh, that's fine. She's already done it once. What do I care? Like I said, old bat out in the world, just kind of doing this. Um, they should, but the thing is that my point is, I guess, is that you know, I can only do things the way that I do them. But I've also made very, very clear that I think that they are, in my opinion, where's my let me see, my opinion. They're gross, super gross. Hey, Toots, it's my cat. Um, so yeah, let's see here. So ah, hello. Okay. Yes, Toots is yes, I agree. Very gross. Okay, so going on to what was shared earlier, and just hitting some of the points. So let me make sure that I have, let me make sure that I have the actual docket, because it's enlightening, to say the least. And I didn't realize that this guy was only 25 years old. That's a lot of bad, for being so young. But man, oh man, what a predator! Um, Let me pull up the docket here. Mm, 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 mm. Say so. Okay. Now this is all available on Court Listener, but some of it is actually not available except to purchase through like Pacer, and I didn't re-up my Pacer account. That's whatever. That Dittmers. Yeah, so this is, please stand by, making sure it's the right one. Let me pull this up first. So this is what was gone through before, right? So, and what this is, so just to sort of ground this in what this is this was a response to the defendant's sentencing memorandum. So what happens in these cases, and most people know this, there's a pre-sentencing investigation that's done, presented to the court, mitigating factors, blah, 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 blah. And so this is the state's response to that that defendant's motion. Now that, so far as I can tell, the actual defendant's motion with Dr. John's forensic evaluation, air quotes, is sealed. And that makes sense in a case involving CSAM, right? So the footnotes, but there's also actually a trial transcript that I found. Yes, and the footnotes are very, very telling. What I'm trying to do, let's see here. So I'm not going to read all this because I think, even Jay earlier was just like, it was pretty gutting, what this person did while in before and during custody, right? And I just want to say that every person deserves a defense, right? Everybody deserves a defense. I truly, truly believe that. Now, this guy, right, has been found and adjudicated. He's had representation. There was an appeal. I was able to find the appeal, which was dismissed, but that's neither here nor there. Appealed his sentence, and so the process has run its course, and it's done its job in this case, right? And so this is going back to the docket after all the trials, and Dr. John is apparently the only expert that these lawyers, and I think that there's probably maybe a connection to the defense lawyers, I don't know, did this evaluation. And as you've seen in Hella's explanation and in Jay's, is that utilized the wrong tools to evaluate this person and apparently seemed to just do as he always do, in my opinion, is just sitting in a room and smell his own farts. That's speculation. So one moment, please. So the real crux of this is this person, and Jay read some of this. So the long and the short of it is, right, that this is the state's response to John Matthias's evaluation. And if somebody tries to tell you it's not, an absolute rebuke of this guy's evaluation, you can tell them they're full of shit or they're trying to sell you something. Because everything in this that I've been able to read, the 31 pages, is predicated on, hey, this guy didn't know shit about shit. And that's the technical term for this, right? So anyway, when we go through this, the entire thing is a repudiation of that. It is. So there was a psychological evaluation done, right? And I'm going to get to the footnotes. The records discuss, and on September 30th, okay, sorry. At that time, Dittmer III, he's the very formal, the third, provided the government with over 200 pages of family court documents. Okay, family court is different than grown-up court, right? The records discuss a psychological evaluation of Dittmer as a child, but the evaluation was not provided. Okay, does anybody know? Actually, this is something I would be very interested in finding out, who did his child psych evaluation. That to me sticks out as very interesting. Who did it? The evaluation was not provided. That's interesting. So again, the long story short here is, you can go back and read about it, but the salient pieces we're talking about how yeah, so they were looking for a variance, a downward variance, on a request, and the request was for, so the actual sentence he got was 27 years, right? We saw that in the FBI report. It's linked, whatever, take a look at it. The family court records do not provide this court with the basis to grant a 17-year sentence. So they were asking for 10 years to be lopped off, right? this is the great part. To the extent, and this has been gone through, but this is just remember going forward. To the extent this court is inclined to give any weight to Matthias's psychosexual report, the government seeks to challenge his qualifications as an expert in the field of adult sex offender recidivism and would request Dittmer III be ordered to present Matthias as a witness to this court for consideration. Right? He's never testified as an expert in federal court, has never testified as an expert as to adult psychosexual evaluations or recidivism. The last time he testified as an expert was in 2011 family juvenile court proceedings, and I would be fascinated to see if this isn't the same person that he's evaluating now. I have no idea. Moving on. So, questions. Sorry. So what this is now transcript. And this is a redacted transcript from the hearing. If you hang on a second, let's go back to the FBI 27 years. Right? Okay. So if we look at this date, November 16th. Okay. So this is a transcript, what I got here. And this is, I have the links to this again. This was on the 15th. So this is the actual certified copy, a redacted transcript of the proceedings conducted partially via Zoom before the Honorable Jennifer Dorsey, United States District Court. Now, here we have, can you see that? Page 23 footnote was of note to me. Can't recall what it is now. God, who knows? But I think that we're going to get down to some brass tacks here. So this is a public document linked in the nether regions of this. So also present USPO, that's, I think, okay. All right, so what this is this takes place the day before the sentencing is released. So let's keep that in mind. So November 16th is the sentencing, when they sentenced him to 27 years. This is the day before. So here we have, I'll highlight it. Ms. Pucci, thank you, Your Honor, Assistant AG. And I'm just going to read through this, so buckle up. On behalf of the government, the victim's mom, okay, it's also here, and the victim's attorney. Now, like I said, this is marked as redacted, so I'm taking them at their word. If I come across something that needs to be yanked down for any reason, I will do that, but it's redacted, okay? All right. So addressing the court, good afternoon, Monty Levy, Russell Marsh, appearing on behalf of Richard Dittmer III. Along with us are some family members, and I believe I have a list. Okay, so they brought a bunch of family members. Okay, we're not going to put them out there. It's not their fault for being related to a monster. Maybe it is. All right, thank you. And this is the court speaking. Then Mr. Dittmer is also attending by video. This hearing is being conducted in part video conference, COVID-19, blah, blah, blah. I'm first going to ask you, Ms. Levy, one, does your client consent to proceed by video appearance today? Yes. Thank you, Your Honor. Yes, he does. Okay, several months ago. So I'm just going to skim through all the formalities. I'm going to turn to you now, Mr. Dittmer. And first of all, good afternoon, sir. Defendant says good afternoon. Do you understand you have a right to appear in person in court for this hearing, but you waive that right to appear by video teleconference? And just to let you know, I'm not watching the chat, so I'm sorry. If you want to, I'll come back and look for questions in a hot second. But anyway, has your attorney advised you the right and ability to waive it? Yes, she has. So has your attorney given you all your blurgity blurg? Yes, blurgity blurg. Your Honor, we're going to ask Denise. Okay, so they're going to ask the aunt to make a statement after he makes a statement. All right. Okay, we want to address an issue we had with regard to one of the victim impact statement that was submitted to the court for the court's consideration. I don't know if the court would like to address that now. We did object to one of the victim statements. So they're objecting to a witness statement. I don't know. I don't know why. Let's get through the guideline calculations here from the parties and let's go on, right? This is a hearing set for the imposition. So this is the judge. So this is the hearing set for imposition of a sentence on Mr. Dittmer in this case. Back in January, he appeared before this court and entered a plea of guilty to receipt of CSAM in count 1, and then in count 2, attempted sexual exploitation of a child. He did this based on a written plea agreement with the government. The court accepted his plea and adjudicated him guilty of these charges. The plea agreement estimated that the offense level under the sentencing guidelines would be 41, although I don't recall if that was before or after acceptance of responsibility. Okay. Court, got it. Thank you. The parties agreed the government would recommend a sentence of 27 years, and the defendant could ask for a sentence and a variation all the way down to the limit floor of 17 years. Okay? So this is the downward assessment. And this is why they brought in Dr. John, right? Again, everybody's entitled to a defense. Everybody's entitled to their experts. But man, oh man, should be experts, right? I've received and reviewed, again, this is the court, memos from both sides. I have the defendant's sentencing memo, I have the government's sentencing memo, and then I have the government's response. That's what Hella and Jay had spoken about earlier on, and did exposition on. I also have, I think, 2 motions to seal exhibits. Okay, so some of those are sealed. The court. All right, these motions seek to seal confidential private medical history. Yes, everybody agrees. Guideline calculation. So they're going to go through the guidelines. Count 1, group 1, receipt of CSAM. So now they're going through all of this, the calculation and the sentencing guidelines. And they're talking about what is and is not allowed. I'm not going to go through all of that. Y'all are welcome to do that. So let's get down to probation, blah, blah, blah. Okay. Turning to the multiple count adjustment, 1 unit at a time. So most people are familiar with this kind of thing. I think that, follow this stuff. But there's some special heat coming up here for the expert in this case, which I thoroughly agree and enjoy. So let's get down to that, shall we? So this is going to be from the court to the prosecuting attorney, Ms. Pucci. Defendant, and so she's going to recount what he did without a lengthy term of, and this is their argument. Without a lengthy term of imprisonment, the government is convinced that the defendant will reoffend again, as he attempted to do so just as recently as a couple of weeks ago. Right? She goes through, she talks about his charges, 2016, 2018, given a third time option, which I can't believe in a sex crimes case against children or anybody, but here you are. He was granted pretrial release, and we all know this. He went through and tried to do all this stuff over again. We would ask to direct your attention to government exhibit number 6, provided for your review. Now, these are images which are sealed, rightfully so. He's proven time and again, he's a danger to society, like all of this stuff, right? So they're listing out all of this stuff at this hearing. Again, 1 day before the court's like, yeah, nah, we're going to sentence him to the 27 years. In mitigation, now this is the part. Mhm. This is the part on page 22. Turn to your hymnals. Sorry. In mitigation, he offers that he's a first-time offender, that he learned this conduct from his mom and his father. I want everybody to sort of listen and see if any of these themes sound familiar based on who is doing the evaluation. Because there's themes, right? A lot of themes that seem to be a one-note cowboy over there acting like they're a forensic, clinical, criminal psychologist, whatever you call it. And I'm the Queen of Sheba. You've read the government's detailed response to these arguments, but I want to briefly touch on these issues at this time. Okay? Learned behavior, right? He's also not a victim of abuse. He himself has indicated and stated to the psychosexual evaluator, which we know is Dr. John Matthias, that he has no recollection of any sexual abuse as a child. The only documentation was from Dittmer III's mother when he was 3 years old. Okay? Defendant also identified his mother had lied multiple times about his father. Now here we go. 24. The psychosexual evaluation is not reliable. Dr. John Matthias is a person who has never been accepted as an expert in the field of adult sex offender recidivism, and his report cannot be relied upon for a further downward variance than the parties have already agreed to. This report is based on evaluation tools that rely on an incomplete definition of recidivism. Anyone? So what this is the answer to this question is this is from the prosecutor's argument. Okay, so I haven't read all this, so yeah. Started watching HTC, right? You know, yeah. It's okay. Zoom in a little bit. I don't know. Maybe. I do have a link. I don't know how to zoom in, but maybe I can. Please stand by while Old Bat attempts to use fancy. Oh, here we go. Sorry. Oh my God. Is that better? So embarrassing. Is it me? Because I'm old? I'm kidding. Okay, hopefully that's better. So let's see. Right. So it's not reliable. A person who has never been accepted as now that has to be, unless it's refuted. So from what I can gather, this is a court proceeding, and everything that a prosecutor brings forward must be the truth, or the truth, unless you're Nick McClellan in Delphi, then you can just lie your face off, right? You just lie. But you, as an officer of the court, you have to present information that is actually true. And so the assumption, unless it's rebutted, and I can't imagine it is, because they got the full 27 years, is that the U.S. prosecutor, and again, this is federal, the U.S. prosecutor did their homework and found that he had never been accepted as an expert in the field of adult sexual offender recidivism. Okay, so that means they did their homework, right? And so this is from 2021, so never been qualified. Thousands of times, right, as a special witness, right? Yeah. So let's see. Based on evaluation tools and an incomplete definition of recidivism, Does anybody want to get this guy a dictionary? You know what? It's almost the new year. Could get him a we could get him a word a day calendar. Huh? Maybe? I don't know. Yeah, I think so. Soap and clay. I love me some soap and clay. So moving on. I'm sorry. Shiny objects. Okay. Anybody that knows me, please educate the people in chat that I'm just so autistic. The tests define recidivism as a likelihood of future arrest and conviction, not for reoffending. Like, sir, tap, 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 sir, you didn't use the right test. Not for reoffending. This court's concern is whether or not Dittmer III will reoffend. And the best evidence of whether someone will reoffend is their sexual interest in children. Dittmer III has proven time and again he has a high pedophilic, interest based on his repetitive behavior, even while in custody. Dittmer III had attempted to satisfy that by ordering images of teenage girls. Now, that's in the sealed record. But even if this court does take into consideration the tests that were administered by Dr. John Mathias, who's never been qualified as an adult recidivism or adult anything in any court anywhere, the court needs to critically examine these test scores. Okay? The government provided those under the sealed exhibits 1 through 5. So the court has access, obviously, to the tests that were administered. And so these are the tests that Dr. John Mathias administered, which were, as you can see above, the wrong tests, right? By a guy who, according to the public court record, and this is a transcript from that hearing, is a person who's never been accepted as an expert. Okay? This is almost like a Trooper Paul situation or Shannon Burgess or Monica Walla, right? Relying on that kind of person. Even if this court, so they have access to all of this. These are sealed, so we don't even know what the tests were that were administered, but the court had access to them and was like, no, we're going to go ahead and give him that full 27. Even Mathias, in his test scoring, has questions about some of his scores, whether or not it should be higher point or not. Wow. So that's a point, apparently, where there was a point of reflection on the part of even Mathias. When looking at whether or not it should be a higher point, the evidence supports it. So here's the thing. I'm assuming that the tests are administered to get a baseline. And then one would have to take, I don't know, all of the evidence provided. And there are some disturbing and startling evidence in this record that precedes the motion that's been read by Helen J. that goes into detail that is so unsettling. And I was going to read some of it, and I'm not. Links are below because it's there's language in the footnotes of what is in this man's history that it makes me sick. It's explicit, um, and nope, nope, not gonna do it. But again, I'll post all of it because I think it's important to see what was ignored, what remained hidden, if you will, from the good doctor. I can't tell you how mad this makes me. I don't know if there's a way to express how mad this makes me. So I'm just going to take a little sidebar here and when you put yourself in a position of power, when you have a large platform, when you claim to be an expert, and when you start evaluating people from afar, be it the absolutely reprehensible, disgusting take on the torture that Mr. Richard Allen endured by the state as not torture, or criticizing victims' impact statements, or getting so upset that you pitch a giant baby hissy fit about a woman lawyer interrupting you. When you position yourself as an expert with so many followers and you represent yourself as a licensed whatever it is, Lord knows I've got heat for a special licensed attorney close to my heart. That's right. You are held to a higher level of accountability. And this is part of the accountability. So when we talk about drama, this isn't it. What this is disgusting. This is exposing lying liars who lie and showing just how bad this whole situation is. Right? So when I see new, I guess when I see new stuff coming out about, unmasking, Rob Reiner's son, a clinical criminal psychologist is unmasking him. Bullshit. Absolutely not. The smoke that I have for this kind of malpractice is deserved. Because in theory, when you become a licensed professional, you are held to higher account. And if you go out there and apparently lie based on the information that we have before us, in this case, dating back to 2016, publicly available in the record, right? These people should not be allowed near victims. They should not be allowed. They should not be allowed near victims. Because the victims in this case didn't give a shit. Didn't even care enough to where's my let's see here. Hang on a second. Didn't even care enough. My little speculation banner. Didn't even care enough to actually look into what this person did, right? Unless, I don't know, My opinion is that perhaps he was this person's juvenile evaluator. Look, man, I don't know. So that's my soapbox. What do you guys think? Oh, hello. Oh, let's see. Hello. Oh, thank you. Okay, so I don't pay attention to chat when I'm reading because I'm shiny things. Did you notice on the page where the mother said she had dreamt it occurred by way of allegation? I did not, but yikes. Okay. Ugh. I didn't. I would have to go back, but thank you so much for that. Hmm. In the transcript, or is it in the court filings? Because I'm happy to go back and take a look. But thank you. Hello. Oh, thank you so much. Aw, thank you. Oh, retired, not bored. Hey, listen, my handle should be old and boring. Hashtag suck it, everybody. Oh, there she is. There she is. Every day with Jay. Right. So we're going to continue this, but thank you. Okay. So, all right, back to it, ladies and germs. Um, let's see. Yes, I did. Let me actually go back. Let me see if I can find. Please stand by. I'm going to go check because I did. Let me just see for a moment if I can find. Let me see. Check the old inbox. Nope. So just to let people know, so what I do is I sent a link to, sorry. So this is in response to a question about, or a statement about giving people a chance to comment, and offered them a chance to comment. They definitely are, right. But what I do is I just sent a link to the court filings and said, I'm going to be digging into this case and would like to know if you care to comment regarding the claim that Mr. Matthias is an expert who testified many times at the federal court, etc. Please see especially footnote 36. So, look, listen, if I'm missing something, I want to know about it. I don't think I am at this stage, but man, oh man, I don't mind having to correct myself. I've had to do it over and over again, and over and over again. All right, so back to this then. Regrounding. So psychosexual evaluation, not reliable. I think that that's the understatement of the century. Dr. John Matthias, the person who never been accepted as an expert, right? That's a Daubert Lanigan or whatever it is, hearings have to be established as an expert. And if you remember from the previous filing, the state, which is the U.S., I guess the district, Northern District, Southern District of Nevada, offered to have Dr. John Matthias come and testify and become a qualified expert, but he didn't. I would have, right? If I had the chops, man, and I had the bona fides, yeah. If I was actually an expert, you bet. I don't know. That's just me. Even if the court does take this into consideration, the tests that were administered to Dittmer III, the tests need to be critically examined. Again, these are provided in Exhibits 1 through 5 under seal. And looking at the actual tests and looking at evidence in this case, the tests actually find that Dittmer III is a moderate to high risk. Okay? The tests actually find. So wait, what am I missing? What am I missing? because I think so he found it, oh God, hang on a second. Interesting. One moment, please. Let's see. All righty, let's go back to our previous document. Recidivism rate. Okay, so lacks sufficient. So I'm going back to this, and again, this is back to, and all of this is linked below in the description for you to access and read at your leisure. Is not reliable. Government asks the court to give no weight to his opinion as a recidivism risk as it, quote, lacks, quote, sufficient indicia of reliability to support its probable accuracy. Okay, and so this is where I'm trying to see what he actually found to compare it to what the government is saying in the sentencing hearing. The government asked the court to give no weight to the predictions of recidivism. Utilize the static 99R, the Vermont assessment, okay. Violent risk of researchers found that applying the VRAG to sexual offenders did not actually predict recidivism. Therefore, okay, he does not utilize the SORAG, the SORAG that was developed from. He does not utilize that. Okay. I'm just trying to see here. Right. Never testified as an expert. Only testified in 2011 in family juvenile court proceedings. That actually tracks with the history that people can find on his employment. Sex offender risk appraisal guide, offending. I'm trying to see, let's see. Okay. I'm just trying to get down to the bottom line here, and if somebody knows, please let me know. Did he find that he was not a risk? I'm wondering if the government called a hearing under 702. They actually offered, so that's, what is that, evidence? Is that evidence rule? I don't know what that is exactly. But there was an offer made to have him come before the court and testify, which I can't find yet that it has been, that was taken up. So that's the best I know right now. And again, I just found out about this at like 10 in the morning, Eastern time. So yeah. Let's see. So apparently, moreover, the actuarial instruments, which are not substantially, okay. So basically they found that no, this is all malarkey. So he incorrectly scored. Okay, here we are. Here we are. Okay. So this was, first of all, he gave the wrong test. So I'm getting it. He gave the wrong test and inappropriately scored. Okay. How did I miss this part? Notably, he placed a question mark next to the stranger victim factor, which would have increased his risk. Now, see, here's the thing. Again, wrong test, wrong scoring of the tests, and apparently no reference to this man, this Dittmers III, to his actual history, which is long and storied and replete with, quote, stranger victims, because that's what he did online. Look. Oh, thank God you're here. Oh, all eyes. Okay, so got it. So wrong test, inappropriate scoring. This brainiac was going to say, oh, apparently based on my testing, which is wrong, which I scored in, and maybe he didn't carry the one. Maybe he didn't carry the one. but did not increase the score for violating conditions of release. Like here, again, just, is it hubris? Is it not giving a shit? Is it incompetence? Is it because you're so busy? What is this, 2021? Telling everybody you know that you are an expert on the Daybell trial. Maybe you got too much on your plate. My God. Oh, look, no, listen, everybody, she's the one out there doing the Lord's work, Hella, not me. I just happened to come across this. And again, the links, if you need any, are in the description. Like all of the what do you call this? Transcript, which we're going to go back to now. So all that, right? So got it wrong, scored it wrong, lowballed him, was like, yeah, this sounds great. I don't know. So again, we're back in where oh, hello, Toots. Hi. What is it? Come here, palate cleanser. Come here. What are you doing? Come here. Let's see. In looking at these actual tests and evidence in this case, they actually find that he is a moderate to high risk, right? So even when Matthias, in his test scoring, had questions about some of these scores, whether or not it should be higher, right? And whether or not looking at it should be higher, the evidence supports it. So this is the government. And they go on to say, and the government has detailed the additional points in which Dittmer scored higher on. Specifically, Government's Exhibit 1 indicates any stranger victims. Matthias indicated 0, which means no. Okay, so this is what the state is saying and presenting in a court of law before a judge, before the defendant, and before all the attorneys and family. This is what they are presenting as facts, right? Matthias indicated 0, which means no. So what I'm reading this to be is that he didn't think that there were any stranger victims, only known victims. Like, that's better. I get it, though. That's like, I get the scoring and the delineation between stranger and whatever. But he indicates 0, which meant no, meaning that in my reading of this is that no, there were no stranger victims in this case of this Dittmers person who has a history going back to his teen years. Okay? Well, this goes on, and this is actually in the transcript. Well, the victim of this attempt, the attempted sexual exploitation of a child, was a stranger. So I'm really upset. Yikes. Everybody breathe. Everybody breathe. So he indicated 0, which means no. The victim, the state goes on, of this attempted sexual exploitation of a child, was a stranger. Okay. Hey, sweetie. Hey, Tim, can you come get this little Toots, please? She wants in the closet. Oh, there she goes. Okay. And it goes on. Sorry. Let me go on. Little cat break. I'm gonna take a Silkwood shower after this, honestly. Seriously, Silkwood shower. Already, so basically what they're doing is now they've entered 1 through 5 as sealed documents. Okay, so these are the sealed exhibits, but they're going to read into the record those overall findings, but keep them sealed. So that's what I'm taking this to be, is that they're saying exhibit number 1, Matthias found there to be no stranger victims, when in fact that exactly is at the core of this case. Already, the state goes on, this should be an increase in a point. And just that one increase puts him in a moderate to high level. Government Exhibit 2, at question 9. Again, Matthias put in parens whether or not Dittmer should be scored a 2 versus a 1. The evidence in this case supports a 2-point addition, which puts him again into moderate and high. Each of these tests administered has such problems. Each one of these tests administers has such problems. And when looking at the evidence, he comes out to moderate or high on a flawed definition of recidivism. Yikes. And the conduct that Dittmer has shown to this court is that he will recidivate without a lengthy sentence. Moving on, Matthias also contradicts himself throughout the summary of the facts. In his report, compared to the summary of the oh my God, okay. Oh, y'all. Okay, just got to get through it. Get out. Matthias also contradicts himself throughout the summary of the facts in this report, compared to the summary of the facts when he makes his opinion. Despite recognizing that Dittmer denied any sexual abuse occurring as a child, and that Dittmer denied seeing his father's child, CSAM, that Dittmer claimed he had first observed CSAM when he was 15 years old with his friends. Matthias blames Dittmer III's conduct in this case on Dittmer being a victim of abuse and observing CSAM at 10 years old. Those facts are not in evidence. And it completely contradicts what Dittmer even told Matthias himself. Anyone? Anyone? Because this is, I guess I should have read further. You guys, no. Okay, so to recap, I'm going to do just an opinion here. Where's my opinion? My opinion here is that the reason that we see so much of John Matthias talking about sexual exploitation and child sexual abuse and all of these things is because that's all he knows. And he only knows it, in my speculation, in a very limited scope, predicated on his Freudian weirdness. He loves him some Freud. He cannot get away from Freud. And I think if somebody did a data cleanse of all of the transcripts from all of the bullshit that person has slung and pulled out the Oedipal complex, you're going to come across, in my opinion, a shitload. Carry the 1. Okay? That's my scoring. Because even though this person, this offender, who is sentenced to 27 years, right? But the prosecution here is saying that even though the offender, Dittmers III, said, no, I was not abused as a child, no, and denied any of such abuse in his own interview or in his own faulty, wrong testing, Matthias, for whatever reason, alleged that no, actually, it was when he was 10 years old is when he started seeing these things. I mean, sees it everywhere. Sees it everywhere, but not in the places that he should. Because the thing is that this person who was, again, sentenced for egregious crimes, who Dr. John Matthias attempted to get 10 years knocked off of his sentence by giving him, did I mention, the wrong test with the wrong calculations, with the wrong definition of recidivism, just spitballed and threw in facts, not in evidence, which is an actual thing in the legal system. So that's something to think about when they pontificate about, and again, they do not know they don't know legal proceedings. Okay? Because when facts are not in evidence, that means that those facts do not exist. And what the state, what the federal government is arguing here, and supported by the own misstatements of facts and the abject wrongness of Dr. John's testing, is that, hey, bud, this guy was not assaulted when he was 10. And hey, the victim in this case was a stranger. So what's the mix-up? What is the damage here? No, that no, no, no. I don't know what it is. I am. You know what? Here's the thing. Thank God this person has not been testifying in trials. Thank God this person is not sought out, unlike, being heavily sought out, right? As the claim. Now, listen, man, if this guy turns out to be an amazing psychologist who is heavily sought after, I will eat my words. But this court, and this is feds, y'all, this is feds, right? Dr. John saw mitigation where there was none. He saw mitigation where there was none. He did not see the stranger victim, which would have increased the recidivism score by at least 2 points. But what he did see was some weird ass fantasy. And when I say fantasy, I mean something he read in one of his Shakespeare plays, or maybe quoting Plato's Republic at his wedding. Hey, I'm not lying. But I can say the greatest gift, tiny baby Jesus, or whoever whoever you look to or don't look to. Thank God this person is not actually working with victims. But the problem is he kind of is, right? The problem is he kind of is. Because he's been allowed, or no, not even allowed, positioned himself as an expert, forensic psychologist, to tell me that a man who was put in prison by the state of Indiana was not tortured because he didn't get hot pokers in his eyes. I mean, it sounds like something that Kevin and Anya would come up with, right? And that was in, so this is an interesting point. Okay. Yes, his last was in 2011, but that was in juvenile court. Right? So that was in juvenile court or juvenile trial, family, something. I don't know if I can get through with this. Let's see. Okay. So basically, the totality of the U.S. District Court in Nevada, the totality of the government's case here as to being arguing for the max is basically, here's everything that John Matthias did wrong. That's a hell of a legacy. That doesn't hit quite the same as the resume one makes up for themselves about being highly sought after. I mean, what? I don't know. Conduct and being a victim of abuse and observing CSAM. Those facts are not in evidence. It matters. This matters. So even though, and this is why imbued in the totality of their body of work, Lauren and John, as journalists and psychologists, one should be able to take everything that they've said about every single case, and I'm going to lean into the Richard Allen case here because I've lost my marbles about that before, and chuck it straight in the bin because they don't know what the fuck they're talking about from a legal standpoint, from process, basic process, facts and evidence. No, sorry. And certainly, my God, their big old series on the Reiner stuff. No, sorry. I'm sure that somehow this will get blamed on somebody's, great step uncle-in-law who did something to this person before they're even adjudicated. This is disgusting. Yeah, give it a Cecil. I don't know. Moving on. Contradicts. Okay, so let's see if there's any redeeming stuff in the defense. Okay. So it just goes on to prevent multiple images of children. Okay, I'm not going to go through that. We're not, nope. Government sentencing memorandum. Okay, today this court must impose, and again, this is the state, and when I say state, I mean the federal government, because this is in federal court, and it must be because, oh my God. Is this where all the deep well of FBI knowledge came from, you guys? Maybe you should get the FBI involved in all the TikToks. Is this where the deep well of FBI knowledge came from? Today, the court must impose a sentence sufficient but not greater than necessary to reflect the seriousness of the offenses, to promote respect for the law, to provide just punishment, afford adequate deterrence, and protect the public, To achieve these goals, a court should sentence the defendant to 27 years in prison and a lifetime term of supervised relief with all the conditions identified in the PSR. That's the pre-sentencing report. Today, the defendant may avoid a lifetime term of imprisonment, but the victims of his conduct will forever live with the trauma he has imposed upon them. The court then says, why should I vary down? And Ms. Pucci is the for the U.S. District Court. The reason why we are in agreement with the two-level variance in this case is to look at the sentencing disparities. So they go on. And it looks like because they're making the argument that the sentencing disparities, as well as to recognize that this defendant allowed the victim to not have to, apparently this plea, take it or leave it, whatever, this was made in accord with the victims not having to come in, and so an exchange was made, which is not uncommon. So there's a victim impact statement in here. And this victim. So this victim is the stranger victim, okay, that was completely ignored in Dr. John Matthias's evaluation. The one that, let's see where it says. Matthias indicated stranger victims were 0. Okay, so let's hear from victim 0, shall we? I was an innocent, normal 13-year-old girl enjoying life when I was approached by a sick grown man offering me money, but I later recognized that it came with a cost. He lured me in, blackmailed me by threatening to expose me all over school. Okay, you want to talk about bullying? Want to talk about crimes? All the cruel things he told me have truly traumatized me. The sick man took away my innocence and my dignity. I was humiliated, and even worse, when we had to go to the police about it, I never wanted to show my face again. I had to force myself to go to school and act like I wasn't hurting. He made me hate myself. I was depressed, anxious, trust issues to the point where I couldn't leave my house during the summer. He affected me so badly that my family started hurting. I became so unmentally stable that my family had to get me help. Lived in a therapeutic facility in Mexico for 9 months away from reality. There I learned to cope with the trauma of that sick man had caused me. 9 months of me hurting and my family hurting. I lost all my friends because of being sent away, having any contact. I blame it all on that man who caused me pain, because no 13-year-old should ever have to go through what I did. It only made me stronger. I never want to see the sick man walking in public. He doesn't deserve that right. Not after what he put me through. No help will ever get you out. You're sick, and you shouldn't ever come out of jail or ever walk the streets again. You don't earn that right. You make me sick to my stomach. I truly hate you, and you've impacted my life. I hope you hate yourself. There's no helping you. Enjoy prison. They don't people like you in there. So that is the victim that was apparently 0. Strangers? Any stranger victims? Nah. None. I am disgusted. So the mother gets up. I'm not gonna read through that. Oh. You know, so yeah. The mother says, I wish he gets the full sentence, even longer, because my daughter's suffering to this day. Okay, this is 2021. Victim 0. The court, thank you. Now, this is Mr. Leventhal. With that, Ms. Pucci says the government rests their case. The government's position is appropriate sentence in this case is a variance to 27 years, followed by lifetime supervision. Yes, plus we'd ask for victim restitution of $29,000 with an assessment of $10,000 and $7,000 per child. Oh my God, to the total of $14,000. Oh my God. Okay, moving along. Oh, here we go. Here's the defense trying to make their argument. I'm just trying to go through here and see if there's anything about John Matthias. So they're asking for a 7-year-old victim impact letter in the family to be stricken. I don't know what that was. All that's sealed. There's been no investigation. Okay. So the state or the government is arguing for it to be back in. Now they're going through and trying to address Mr. Dittmers. Okay. That was it. That's it. No pushback on that psychological review. Nope, got nothing on that. Didn't ask, didn't push back, nothing. So the nature and characteristic of the defendant and issues and whether or not he needs a lengthy sentence and the history and the allegations against him are important for this court to take into consideration imposing sentence. Okay, so the court, Mr. Levy, last statement on this point. Yes, Your Honor. So they make some, Miss Levy is, and again, everybody needs a defense. So everybody deserves a defense. But this is, sentencing. So basically all they're asking is for one victim impact statement to be removed because it wasn't investigated. All right, thank you. I'll reserve statement. Until then, I'll pronounce sentencing. Thank you, Your Honor. Let's see what the judge has to say. Government states on fisheries, photos. Okay. I'm no expert on this, thank God. Well, this is the defense attorney. I'm no expert on this at all. I'm familiar with this charge. Okay. Here we go. So this is from the defense. The second point I've been asked to address regards the report done by Mr. Matthias. And Ms. Levy and I have had a chance to talk with Dr. Matthias, and we'll go over the government's response to his report, which was, of course, attached to our sentencing memo. Okay. The first I would note is that this isn't a battle of experts. Okay. And this isn't a battle of experts. This is okay. Wait a minute. Mr. Marsh. Okay. So this is for the defense, right? So so the second point, so they are going to address his nonsense. And I think that this is interesting wording. And I honestly don't think lawyers say things without thinking about them. The second point, and this is the lawyer, Mr. Marsh or whoever. The second point I've been asked to address regards the report done by Dr. Matthias. And Ms. Levy and I have had a chance to talk to Dr. Matthias and go over the government's response to this report, which of course was attached to our sentencing memo. First, I would note that this isn't a battle of experts. The defense has an expert. The government doesn't have any expert to refute what the defense says. Huh, that's, oh, okay, hang on. Okay, this is good. Okay, the defense has an expert. The government doesn't have any expert to refute what the defense says. Instead, the prosecutor herself is the one who critiques what our expert said. She tries to rescore tests as if she were a psychologist and psychiatrist. Sound familiar? Wow. Ooh. Oh, what? Wow. She tries to rescore. I have a feeling that there's going to be a response to this. So let's see. She points out, as the government invariably does in these types of cases, that the only thing that would have sufficient would have been to do a blank, indiscernible. I won't try to pronounce that, what it means, but of course, it's impossible to do in a detention center setting. Okay. Now here, okay. I think I can suss out what this guy's trying to sell. And I think what he's trying to sell here is that but he was in detention though. I'm going to reserve my judgment for a minute, but okay. I would note, so he's going to go on. Again, I want to go back to this. I've been asked to address. So I am just going to throw an opinion out there that these lawyers were asked to address this report after they had a chance to talk to Dr. Matthias. That's what I'm going to guess. Let's see. Defense goes on to say, I would note that evaluations like this are admitted as expert testimony in courts all over the United States, including the state of Nevada, in order to determine sentences in child exploitation cases. So it's perfectly acceptable for this court to take into account in determining how far to vary in this case. The second point I would like to make is that in speaking to Dr. Matthias, he pointed out the government's argument. Oh my. The second point, the second point I would like to make is that in speaking to Dr. Matthias, he pointed out that the government's argument in response is based on a false reading of the family court record. What does family court have to do with that? And I will admit, this is the defense going on again, and I will admit that we went out of our way in the defendant's initial sentencing memo to be balanced and say that report was ambiguous. But in actually going back and looking at the report that was done, it's not about the mom having a dream. She said specifically was that she saw a dream. What she said specifically was that she saw a dream. And I'm quoting from the report, which says, I believe I want to say, family court record, 157 of the family court record. Okay. She saw a dream concerning the child being possibly molested, and now that's come true. And then the child had verbalized the father had assaulted him. As Dr. Matthias pointed out, it's not as if 3-year-olds make these things up very often. Oh boy. Oh boy. They're not going to disclose something they don't understand unless there's some truth to it. This sounds familiar. So the government's reading that at best is incomplete. And that's why I wanted you to have the entire statement. The defense goes on. You know, the one thing that struck me, I think, the most in reading the government's initial sentencing memo and its response to our sentencing memo is how many pre-Booker cases. Okay, here we go. Okay. So now they're going to the law, a burden to prove. Okay. hmm hmm So what they're arguing here is how many pre-Booker cases they rely on, as if the defense has some sort of burden to prove that there needs to be a departure in this case. Um, okay. So it's a sentencing memo, right? I, I don't. I think it's a response to your memo, sir. I don't know. As the court well knows, you should depart. You could depart that far based simply on your disagreement with the child exploitation guidelines. Okay. The government is asking for a sentence that's higher than the average homicide sentence by far, and obviously victims in those cases make exactly the same argument, and this is not, though. The government says that Mr. Dittmer should be treated as a repeat offender. Oh, okay. Just keep reading. The government says that Mr. Dittmer should be treated as a repeat offender. I wanted to explain to you why Dr. Matthias did not do, here's what I want to know, actually. Why isn't he in there making this argument? I'm not kidding. I mean, it seems to me that if this were me, first of all, I'd want to know if there were any recordings done during the interview about this dream, not dream. Also, that from what I can gather here in the record is that that's from a juvenile court case, which can we talk about the zero stranger victim? No addressing that yet. Maybe it'll be in here. But Dr. Matthias was given the opportunity to come before the court. Why was that not taken? I would have taken that. Wow. The government says that Mr. Dittmer should be treated as a repeat offender. I wanted to explain to you why Dr. Matthias did not do that. It's because the only thing that's been proven or admitted is the facts in this case, which is 2 counts. They're taken together. This is one case. Oh, man. But it was only one case, though. It was only one count. Wow. But it was only one count, though. Well, when you got nothing, you got to argue something. They're taken together. This is one case. That's why he did not consider him to be a repeat offender, just as if this court will only be sentencing in one case. Blah, blah, blah. Let's see. Oh, gross. Finally, another point. I don't want to belabor this, but despite the severity of count 2, Mr. Dittmer has never been convicted of any contact offense. Okay. Okay. And with Miss Levy pointed out, the issues with the allegations regarding the 7-year-old, which only came to light during the father's sentencing. Okay. What about that one? Okay. Oh boy. Finally, I want to respond to the idea that's been argued repeatedly by the government that we're dealing with a full-grown adult as somebody whose conduct indiscernible, like a much older man, like his own father, who was sentenced to this court to 63 months. Okay, developing brain, yap, yap, yap. And It started back when he was young, 18 or 20. Thank you, thank you. Give me just a second, please. Okay. The most recent incident when he was 22. Sir, that is a full grown. That by the law is a man. So, you know, while I think that I'm going to go off here for a minute. While I think that it is okay to talk about brain development, I think that that runs counter to what the actual law is in this instance. And the idea that because, sorry, I'm moving around, that because there was only one count or that they combined, that's like, I don't even know. Thoughts? I mean, come on. All right. What are you guys talking about? Let me look over here. Yeah, I mean, I would say so. And here's the thing. Look, the defense has got to argue what they're going to argue. That's their job, and everybody deserves defense. But, oh, this is good. So let me get this straight. This guy is a low recidivism risk, yet Christina is high. Yes. Got it. Correct. Correct. Right. So it is a sentencing hearing. You bet. So they have to argue mitigation. I mean, they just do. I get it. The law is the law, man. And truly, here's the thing: is that I think that we're missing the point. Hang on, Your Honor. We're asking this court to sentence Ricky. Ricky? Huh? Oh my God! You're kidding. His name is Richard, right? Ricky, to a significant amount of time, 17 years. Ricky is today 25 years old. Okay. Uh-huh. Ricky. Wow. Okay. What? Okay, but hang on a second. Wait a second. Ricky, during his psychosexual evaluation, which, as Mr. Marsh pointed out, these are evaluations. Dr. Matthias has been recognized as an expert in these evaluations. Where? Where, though? These reports are relied upon heavily in the state system. To look at the amount of the time that CPS responded I can't, you know what? Stop it. Ricky. That's wow. That's coming in hot. When Ricky was interviewed by Dr. Matthias, and throughout this case, for the year he's been in custody, he's been confronted with the fact there's so much evidence of abuse. And he has this lack of memory. He's not lying. Well, then get him some mental help in the 27 years that he's going to be sentenced to prison, right? Look, damaged people damage other people. And two things can be true. I can hate that if the abuse that this person suffered is true and borne out. I hate that. Does it make what happened and what this person did okay? Hell no. Does it make what apparently, where is it? Let me see. Where's my opinion is that, man, when John Matthias found out that the government said, this is bullshit, he didn't score this correctly, oh my God, that John went back to the lawyers and said, here's what you tell him. You tell him, nuh-uh. Nuh-uh. Jesus. Yeah, it's a broken home. You bet. 100%. 25-year-old man, though, right?
25-year-old man soliciting a stranger who Dr. Jean Matthias pointed out there was no strangers. That stranger, Zero, gave a witness impact statement, as did her mother. Yet here's what strikes me is so gross about this. Well, maybe I got to keep reading. Hang on a second. Very downward. Ricky was exposed, blah, blah, blah. Okay. Has an incredible amount of family support. Okay. All right. But remember everybody, that Richard Allen wasn't tortured because they didn't stick hot pokers in his eyes. Okay. That's a Dr. John original. Nuh-uh. That's my defense. I'm trying to see. He's apologetic. Okay. Okay, let's see. These allegations are very serious. He's apologetic. We would never say that he is. The images children depicted are absolutely the victims, but Mr. Dittmer was never in the same room with them, never touched them. And as Dr. Matthias indicated in his report, and it's on page 42 of his report, which is wrong, sexual attraction to children, especially when they are not exclusive, as is the case with Mr. Dittmer, and that's because he had age-appropriate relationships with girlfriends, can be managed and abated with counseling with help. Boom. Wow. You know what? Sexual abuse is something the only time I've ever reported on those cases are in the case of a guy that went out and reoffended and reoffended and reoffended, and started at home, started in his own backyard, literally with his own family, spiraled out from there across 3 states, started when he was a juvenile. That's only one person that I'm aware of. But I got to say, my evaluation is just as good as this feller, saying that just because you aren't in the same room with them, right? The Keegan Kleins of it all, the downloading RAMs of CSAM, making excuses. I don't understand how you circle the square here. And I think that this is the whole, we're in it for the victims, comes in for me. The ego on this guy. The ego on this guy. I want to know who was his counselor? Who was this Richard Dittmer's counselor as a juvenile? Because I think that would tell us a lot. He was asking for help. Okay. Was he? I don't know. Dr. Matthias indicated in his report that, and it's on page 42 of his report, that sexual attraction to children, is this even true? Is this even supported in literature? Sexual attraction to children, especially when they are not exclusive, as is the case with Mr. Dittmer, because he had an age-appropriate relationship with girlfriends. Okay, is this even true? Let's go back. Let's go back and see. CSAM and sexual exploitation. This is from Las Vegas, U.S. Attorney's Office, District of Nevada, November 16, 2021. Sentenced to 27 years in prison for attempting to sexually exploit a child and for receiving child CSAM materials using file sharing networks. The FBI is committed to stopping and holding these accountable, gain easier access. According to documents in June 2016, Fred Dittmer utilized the BitTorrent file sharing network to download CSAM. During the execution of a search warrant at his residence, he admitted to receiving images and videos of CSAM as well as uploading. Okay, uploading as well. So he wasn't just a consumer, right? It wasn't just for personal use. And I hope you can hear the snotty bile in my voice when I say that. He was uploading them on YouTube. Which what? Excuse me? So I'm assuming that means he was uploading it to a private link to share with his buds. I don't know. But that suggests to me a propensity to, I don't know, be a douchebag and spread this around. Sorry, guy. But he had age-appropriate relationships, though. No, these federal crimes, sir. These are federal crimes. So that's the other thing, too. It's not just the abuse and the CSAM, which is disgusting. It's also the fact that it's federal and you effing use the intertubes to share child sexual exploitative material. That is a federal crime. Now, perhaps Mr. Mathias doesn't know that because he's never testified in a federal case as an expert. He's only ever testified in a juvenile court in 2011. Okay? I don't know. Coerced. Here we go. This is okay. All right. Here we go. While on pretrial supervision, Ricky, right? So this is the guy that Dr. Mathias is making the doubling down, saying, I didn't use the wrong thing for recidivism. I know what it meant. But hey, didn't know what it was meant. Didn't know. Well, in pretrial supervision, okay, Dittmer coerced a 13-year-old girl. That's stranger victim 0 to Dr. John. Thinking on Snapchat into creating. So he's a purveyor. He's a consumer. He has a little cottage industry of creating it and distributing it, right? So I want people to keep it in mind. This is important. It's the totality of what this person has done. And again, yes, hurt people hurt people. This man very well could have been abused, and that's wrong. But this 25-year-old man had a choice to make. Okay, let's see. Hang on a second. Ugh, gross. We're not going to hear from Mr. Dittmer. Blurgity blurg. Ricky Nose joked about yap, yap, yap. Let me just see if the state has anything else to come back. As an addict, okay. You know what? Let me see. Judge Dorsey. Hang on a second. People do change. Okay, great, 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 great. Richard's aunt. Okay. He's caring, he's loved. Okay, that's great. All that's great. Realized his decision and actions have affected more people than just himself. All right, great. Deeply regrets it. Did he? Because when he was out on release, he was creating CSAM by coercing a 13-year-old man. Allegations against 7-year-old cousin. Oh God, I'm not going to listen to them slandering a 7-year-old. Let's see. Nothing. Okay, so this is a family oh God. Ooh. Okay, I can't read this. Nothing in their behavior sent up red flag. So apparently she's an expert too. Got it. Okay. Thank you, Miss Levy. Is there anyone else who wanted to speak on behalf of Mr. Dittmer before I hear his statement? I started my recovery over a year ago. Nope. Do not. Don't bring that into it. Huh? The subject matter is vile. Yes. Ooh. Yeah. Yeah, this is rough. Recovery. Okay. I just want to see if they put anything on the record from the government about I'm going to have to scan this and see. Let's see. I've heard and considered the charging documents. Okay, so the court, all right, to reiterate, the government is asking for a sentence of 27 years. The defense is arguing for 17. Probation is recommending a total aggregate sentence of 420 months. Heard, read, considered. Charging documents, plea, and the pre-sentence investigation, the sentencing material provided by both sides, arguments and statements from counsel and from the defendant, victim's mother, blah, blah, blah. Okay. I'm going to disregard, okay, let's see, disputed nature of the information is unrelated to the specific conduct. I simply don't need it, and I'm going to take it into consideration. Does that resolve your objection? It does. There are a number of considerations that factor in. These offenses are undeniably very serious. Mr. Dittmer was in receipt of CSAM. He wasn't just passively in receipt, right, of such materials. He was actively seeking personal connection with minors for CSAM. This conduct under the guidelines results in a sentence of 600 months, which is 50 years. But even probation does not believe a 50-year sentence is justified. And I also acknowledge the sentencing guidelines are extremely high for this. I'm required by the law to consider the facts, the offenses, and that requires me to base my sentence on a thoughtful application of the 3553A factors instead of arbitrary congressional decision. I do find the guidelines are particularly child pornography offenses are excessive. I've said this before, and I've ruled this way before. I continue to feel that way. I think well. So I have policy disagreement. Okay. I recognize the significance of a custodial sentence and is necessary to deter this conduct. In the future, the victim individually, particularly the young girl that he inflicted, that's patient, or zero, what do you call it? The unnamed or the stranger victim, inflicted this psychological terror upon, used to manufacture. So yeah, the plea agreement, okay, stipulated personal history, family support, no criminal history other than parking traffic. He does have a tragic childhood, right? Indeed, his own father was his co-defendant. Oh, Lord, didn't know that. Mental health, addiction issues, right? He committed the offense conduct in the incitement count with pretrial release, which does not bode well for his compliance on supervised release, right? That's the point. That does not bode well. He's unquestionably a predator, and the community must be protected from him. So it's that he committed this offense while on a pretrial release. Good grief. The record should reflect I have fully considered the psychosexual evaluation by Dr. Matthias and his conclusions, including the ones the defendant is not likely to recidivate or doesn't have a high chance of recidivating. But the defendant's conduct shows that his actions are repeating, that he is a recidivist in 2014, 2016, and 2018. And even as recently while in custody, it appears, he's gotten a hold of anything that he can that is even close to child CSAM. I think we can possibly get, including bizarrely, little girls' magazines. This is his criminal conduct. His predatory criminal conduct has been undeterred by supervision. This is not a notion that the defendant is someone who just engages in fantasy. Perhaps, I think, went out the window when he started Snapchatting and extorting a 13-year-old girl for a lengthy period of incarceration is clearly necessary. So let's be clear. This is what the judge says. The record should reflect that I have fully considered the evaluation by Dr. Matthias and his conclusions, including the one that the defendant is not likely to recidivate or doesn't have a high chance of recidivating. The defendant's conduct, and this is the court, directly rebutting Dr. John's conclusions. But the defendant's conduct shows his actions are repeating that he is a recidivist. 2014, 2016, 2018, and even as recently while in custody. I don't know, man. Seems like a pretty decent rebuke. So, yeah. Yeah. Right. Considered it trash. Yeah. This is horrible. This is just horrible. So he was, again, he was sentenced to 27 years. And the court took one look at the, yes. Yep. And this all, yeah. Gray space. Hey, girl. Kitties. I feel like, so I haven't even been paying attention, but I'm going to wrap this down because I'm exhausted and angry. I feel like he would have been a better mitigation expert if he had done his job right. I mean, yay, girl. Cleaning out your shed. Oh, Cindy, how are the chickens? How are Kimberly and Katie? I'm sorry, R.I.P. to the chickens. Yeah, so there there is an actual docket. So again, I'm just trying to recap here, and there's no way to recap because this is just too much. But I think it's worth reading the transcript because it does. There's nothing in there indicating that he was a certified in any court, and you know, to be clear, the defense didn't present any record on the evidence, or it didn't present any record of any time that he had ever been an expert witness in adult cases. And that is a clear delineation, and one that the prosecution made, is that he only ever testified in a state court, not in federal court, as of 2021, apparently in family cases. And maybe, man, just stick to that lane, right? Stick to that lane. Yes, all the filings should be available to everybody. Interesting. I suspect this is the case he was referring to in the body cam footage. Woo! He worked with law enforcement on sex crimes. Yeah, I mean, I kind of get the feeling that this is probably just the one case, right? But I don't know. I mean, I'm happy to be wrong. I truly am. I mean, anybody that knows me knows I don't really give a shit if I have to correct myself. But man, I'm just reading straight from the documents, and I don't know. It's pretty clear. And the actual documents that I was going to share and that I mentioned earlier were too graphic. It's the graphic nature of it is such that it is I don't even like reading it to myself. But that said, they are linked. So again, this guy, let me see if I can do one last ditch effort here to find the because I think it's important to talk about the 2016 arrest, because again, this is not a one-off. And so the idea that, hey, this guy isn't going to reoffend is not let's see, is not well thought out. One second. Trying to get court listener. Here we go. Is this it? Yes. Okay. Let me bring this back up then. Okay. So let me see if I can put a link. Yep. Thank you. Let me see if I can get a link. So this is the docket I've been talking about. So copy. Sorry. Okay. So this is, so if you have a Pacer account, and I just haven't re-upped mine, I guess I should, but this is the docket. So this goes back to, let's see, I guess the first filing was in September 26, 2018. Now, if you remember from the hearing, he was on pretrial release when he committed the offense with the stranger zero. Let's see. So all of these, you can actually, I don't know if you can see this here, but you can buy it on Pacer. But there are many that are downloadable. Probable cause. So this is sealed. Yikes. PCR. Okay. All right. GPS. So you can go through and look at all of these things. But so there are some things that are either, they have overviews of what was like minute, minute documents or minute rulings. And then there's minute proceedings. Then there's other orders. So we come down here to notice of attorney, order to continue, stipulation to continue. Okay. Then you come down here, you see the docket, right? Order of forfeiture. Okay. So preliminary order on forfeiture. So you can download that. Granting a 99 stipulation, sentencing deposition. Okay. So this must have been when he pled. And you can download that. Stipulation, download, let's see. Yeah, so this is just, so a lot of this is the continuances, sentencing memorandum by the USA, okay? So this is the one I think that gets into a lot of stuff that I just cannot. Is this the one? Yeah, so he had over 4,000 files. So you can go and look at this. Again, it's rough. All of this is terribly, terribly rough. Protective order. So this is probably things filed under seal because it is underage, because it is CSAM. So what Hello read was the response. So this is the state's response to the evaluation. And keep in mind, all models contained in the site were over the age of 18. Now, this list, and I think it's important too to understand everything that Dr. John had at his disposal, right? Okay. He relies heavily on the family court records. I wanted to find that part where invited, hang on a second. Expert. Okay. So yeah, this is the 36. To the extent this court is inclined to give any weight to his report, the government seeks to challenge his qualifications as an expert in the field of adult. Okay, so the government was seeking request that Dittmer III be ordered to present Matthias as a witness for this court's consideration. Okay, so keep this in mind. So when and if HTC ever decides to come back and strike or whatever they try to do, whenever that happens, and it could, right? Could. Remember that the state or the government, the federal government, challenged Dr. John Matthias to come before the court and testify that, and the gravity of this is critical. And perhaps this is where I'll end because I'm tired. Again, old, tired, etc. To the extent this court is inclined, okay, we got all that. The government seeks to challenge Matthias's qualifications as an expert in the field, okay, would request that Dittmer be ordered to present Matthias as a witness for this court's consideration. Okay, that to me is the big one. They were like, we want him brought in here to testify before us on Mr. Dittmer's behalf. And let me go back and see if there was ever an order. Let's see. That was on November 1st of 2021. Violation, let me see. Court administration. I did not. Okay, so I don't see. What is this? Final order forfeiture. Let's see. Okay, this is just he has to forfeit his stuff. I don't see that there was ever an order or a request for order, or any sort of motion that was filed to have Dittmer's expert come testify. But sentencing hearing scheduled, okay. But it is notable that didn't show up. And the thing is, I wonder what was happening around this time in their lives. So the sentencing memorandum, that was on the 14th. I'm just trying to get the timeline. So from September 14th, when they essentially walked out and you know, like in some fancy Shakespeare play, walked up and slapped Dr. Matthias metaphorically with a glove to a challenge. He had from September, October, November, till November, right? To come in and present his bona fides. Yet he did not. Did not. So, I don't know. So yeah, I linked to this. Have at it. So the redacted transcript, that's what I just went through. Here, arraignment and plea. Interesting. Now, there may be other stuff in here that could be purchased. Mandate, notice of appeal. Yeah, so, appeal. Sorry. So yeah, I've thrown that out there. Happy hunting. Thanks, Jay. I'm exhausted and it's gross. And thanks for dragging everybody over here. And to people who just joined and gifting memberships, thank you. And my super chat, yay! I don't do this very much because, as I mentioned, I'm an old bat out here in the world. It's actually in school. But yeah, I don't know. You know how I roll. So take a look at that timeline. Yes, and this is true. Andy is absolutely the queen of the Irish goodbye. And also, I only ever strive toward mediocrity. So anyway, yikes. Sorry, I guess, is all I can say to you and yours. But that is yikes. And I look forward to Hella and Dolly and Jay and Jolene and their enlightening streams. And this is what happens when in my opinion, when creators come together and try to actually do some good, and John and Lauren may not think this is good, but anytime you can shed light on something that is clearly demonstrably false and has been shoved in our faces, instead of pitching a hissy fit and going on a 9-hour live and bitching about being, you know, targeted, you actually build one another up, right? Lift everybody up. So anyway, yes, Irish goodbye. So as I always say, I hate all of you.